Right. I think that we can get started, and if anybody's missing, then we'll Songxi, you're on.
Okay, so shall we start now? Okay.
Yes, please go ahead.
Okay, sure. Hello, good afternoon, everyone who is joining the webinar online and in Beijing office or in Shanghai office. Welcome to the webinar organized by the EU SME Centre, China IPR SME Help Center, and along with the European Chamber and the Swedish Chamber. And today we have the webinar. The topic is to have an overview of the revised patent law and the copyright law. My name is Songxi Guo. I'm the Vice Chair of the European Chamber IPR Working Group. And also I work as a Senior Patent Counsel at Bayer China. So as we know, insufficient patent and copyright protection and the enforcement in China has been a long-standing problem. And finally, on June the 1st this year, the revised patent law and the copyright law have become effective. And these amendments have brought substantial changes to the IP systems in China, such as the establishment of patent linkage system and patent term extension systems. And also, we have noticed the protection period for design patents have been prolonged, and also punitive damages for bad faith infringement has been introduced into the law system, and also the extension of copyrightable works have been incorporated in the new copyright law. Therefore, it is very important for foreign companies who are doing business in China to understand these changes in order to protect their IP rights and legal rights. Accordingly, today we have invited two experts, Mr. Xiaofan Chen from AWA Asia, who will explain the new patent law, and Mr. Matthias Zubimendi from China IPR SME Helpdesk, and Matthias will introduce the changes in the revised copyright law. Before their presentation, I would like to take this opportunity to give you some brief introduction to the EU SME Centre, China IPR SME Helpdesk, and the European Chamber and the Swedish Chamber. The EU SME Centre is a European Union initiative that provides a comprehensive range of hands-on support services to European small and medium-sized enterprises, which get them ready to do business in China. Our team of experts provides advice and support in 4 areas, including business development, law, standards and conformity, and human resources. Collaborating with external experts worldwide, the EU SME Centre converts valuable knowledge and experience into practical business tools and services easily and accessible online. The China IP SME Helpdesk supports European Union small and medium-sized enterprise to both protect and enforce their IP rights in mainland China, Hong Kong, Macau, and Taiwan by providing free information and services, including jargon-free first-line confidential advice on IP and related matters, plus organization of training seminars and webinars, and the provision of materials and online resources. The European Union Chamber of Commerce in China is a members-driven, non-profit, fee-based organization with a core structure of 26 working groups and 8 fora representing EU business in China. The IP working group consists of European enterprises, law firms, and consultants who are engaged in anti-counterfeiting work and research on IPR-related legal matters. It monitors IPR developments in China and raises concern before Chinese and European authorities. The Swedish Chamber of Commerce in China is a non-profit, non-government organization with about 200 Swedish and Sweden-related member companies. It is officially recognized as foreign chamber by the PRC. The role is to enhance the business opportunities for the member companies in mainland China and aim to be the central meeting point for the member companies as the networking information and the facilitator platform. The Swedish Chamber is very pleased to continue IP-related topics this year and partner up with China IPR SME Helpdesk, the EU SME Centre, the EU Chamber, and the European Chamber, and is also very glad to see one of their company members, AW Asia, could be part of this webinar and share their expertise and exchange patent-related knowledge. Okay, so with the above, I would like to invite Mr. Xiaofan Chen from AW Asia to start his presentation on the revised patent law. So thank you, Mr. Chen. Hello.
Yes, we're on. We're changing the slides now.
Okay.
Okay. Hello, everyone. Whether you are attending this seminar in person in Beijing, or you are watching this webinar online, thank you for attending. Today, I'm going to give an overview of the Fourth Amendment of the Patent Law of China, which has just come into effect in the first of this month. This new amendments of patent law has brought a lot of changes to the patent practice in China. And we believe it will have great implications on the businesses operating in China, including multinationals and small and medium enterprises. So today we are going to look at some highlights of the Fourth Amendment of the patent law and look at the implications that they may have to the, especially to the foreign companies, including SMEs. Before we dive into the details of the amendments of patent law, I'd like to give you a snapshot of development of patent law of China. I think many of you know that the patent regime of China is quite young. Actually, the first patent law was enacted in 1984 and came to effect in 1985. Since then, there have been 4 amendments of the patent law. The first one is in 1992. The second one is in 2000. The third one is in 2008. And most recently, the Fourth Amendment amendments in 2020. And the new amendments have come into effect from June the 1st, 2021. If you look at the numbers on this slide, it is interesting to note that for the first 3 amendments of patent law, it generally took 8 years for each of the amendments. The first one in 1992, then 2000, then 2008. But for the fourth amendment of the patent law, it took 12 years. That's why this law has been very eagerly expected by the industries, by the IP protection. This law actually, we believe this law will bring a lot of changes and have great impact on patent practice, because the many changes made in this law, many amendments made in this law actually are the direct response to the social and economic changes in China over the past 10 years. So let's move on to the highlights of the amendments of the patent law. I would like to summarize the highlight of the amendment of the law as 4 pillars. The first one is about patent enforcement. From the many new provisions and new amendments, we can see that China is willing to further strengthen the patent enforcement. The second one is about industrial designs. Industrial design is a very important form of IP, which is important for the company to protect their innovations and improve their competitive edge, especially for small and medium enterprises. The third one is about the new provisions directed to pharmaceuticals. As Songxi just mentioned in the opening remark, there are some new provisions about patent linkage system, about patent term extensions, which are all related to pharmaceutical patents. Last but not least, there are some measures in this new patent law for promoting utilization of patents. Apart from the 4 pillars, there are some other elements in the new patent law which is worth mentioning. There are provisions about general patent term extensions for invention patents. And also there are some changes to the provisions regarding employee inventions or service inventions. And very importantly, there are some new provisions against bad faith patenting activities and abuse of patent rights. So let's have a closer look of the four pillars of the amendment of patent law. When it comes to patent enforcement, the most significant change in this new law is about damages, including statutory damages and punitive damages in the patent infringement proceeding. Many of you know that China has been long criticized by the low damages awarded by court in terms of patent infringement litigation. I must admit that it is true it is true for the past maybe 8-10 years. The reality was the damages awarded by the courts usually were very low. Sometimes it's just sometimes just nominal. It made people to think that enforcement of patents in China is worthless because in the end, the damage awarded by the courts probably could not recover the legal fees for the cases. But the situation is changing, actually has changed over the past few years. In the legal practice, we have already seen the damage awarded by the courts is increasing. And now the new patent law has codified the damage, the statutory damages and the punitive damage at a new level. In the new patent law, the statutory damages is increased from previously RMB 10,000 to 1 million to RMB 30,000 to 5 million. Back in the, I think back in 8 or 10 years, the reality of the damage awarded in China was, the situation was many cases were decided with damages awarded using the statutory damage towards the lower end of the previous statutory damage. But now the situation is changed. China is willing to change this situation by increasing the statutory damages. And need to go back. Okay. And also very importantly is the new law has introduced the punitive damages for willful infringements. The punitive damages can be awarded 5 times the damages normally assessed. This is a provision that are very welcomed by the industries, by the patentees, and by right owners. Apart from the damages, there's a great improvement about evidential procedure. Actually, this kind of evidential procedure has already been practiced in many courts already. But as the damages, the new law has codified this this evidential procedure in the patent infringement litigation. Basically, there are some provisions regarding the evidentiary burden shifting from plaintiff to defendant under some circumstances, especially for the court to decide damages. When it comes to patent litigation, we always say evidence is the king. This is very true in China because unlike in some other countries, such as in the US, China does not have the discovery procedure, which requires the parties of the litigation to disclose the evidence to each other and before the court. So in the litigation in China, the plaintiff generally always has the burden to collect evidence for everything, to prove the ownership of the patent, to prove the infringement of the defendant, and to prove the damage. As you can imagine, this burden can be very heavy. Sometimes, because of this kind of burden, the plaintiff cannot probably bring a case to the court. So this is also a great improvement from the perspective of the patentee or patent owners. Last, there are some provisions regarding the clarification about the power of the administrative authorities in terms of dealing patent infringement cases. First of all, the Patent Office, CNIPA, has been given a power to deal with patent disputes of national significance. Also, some powers of administrative authorities, such as the branches of the patent offices, the local branches of the patent office across China. The law clarifies that they should have some power to deal with patent disputes. For example, they have the power to question the involved party, and they have the power to examine the size and the products of infringement. This is very important because the records of the administration, the records of administrative authorities for conducting this, conducting their duties, such as questioning the parties and examining sites and products. These reports can be readily permissible to the court as evidence. So actually, this provision, in a way, can reduce the burden of the plaintiff when they bring the case to the court. The second pillar is about industrial designs. First of all, the patent term for designs is extended by the new law from 10 years to 15 years. But this rule is not retrospective. The extended term applies only to design applications filed on or after June 1st, 2021. Also, partial design protection is available for the first time in the patent law. This is very important to for the company to offer protection to owning a part of the product. Previously, the design law of China can only protect the outer appearance of the entire product, not a part of the product. So the new law offers this new protection for owning a part of the product, such as a distinctive portion of the car or an armrest of a chair. And this provision is extremely useful for protecting the designs of graphical user interface, GUI, because we now living in the world of apps. Each app has their own GUI, and many companies spend lots of money and energy to design their GUIs, and they need the protection for GUIs. The previous law actually did not protect, did not offer sufficient protection for GUI, because the GUI was considered as owning a part of the product and not be protected by itself. Now the new law actually gave company new opportunities to protect their designs of GUIs. Another thing about the industrial designs is the introduction of domestic priority. This provision basically makes it possible for domestic applications to be adapted in view of the further development of the design of a product. This is particularly useful for international companies having local R&D facilities in China, which filed a lot of domestic design applications. Now let's have a look at some new provisions regarding pharmaceutical patents. First of all, the patent term extension is introduced for new drugs. Many of you know that for a drug to be put on the market, market approval is always needed in almost every country. And the actual situation is it usually takes quite a lot of time for a new drug to obtain the market approval. This new provision of PTE actually is for the applicants or the pharmaceutical companies to make up for the time spent in obtaining the market approval for a patented drug. According to this new provision, the PTE is up to 5 years, but with a condition, which is the effective patent term does not go beyond 14 years after the grant of the market approval of the patented drug. Because obviously there is a balance to be strike between the interest of the drug company and the public who needs easy access to the new drugs. Another new development is pharmaceutical patent linkage system. This is the third time China has introduced this this concept in the patent law. Generally speaking, the patent linkage system is an early dispute solution mechanism for addressing the disputes between innovative drug companies and the generic drug manufacturers. I think many of you know that generic drugs actually are the copies of innovative drugs. And generic drug companies rely on the technology of the innovative drug companies to produce their drugs. So when the generic drug company wants to put their drugs into on the market, they need to wait for the expiration of the patents of the innovative drug companies. But the situation in China is because of the isolation between the two administrative authorities, the NMPA, the National Medical Products Administration, and the Patent Office, because of there's no communication between the two parties. Sometimes generic drugs may be put into the market before the patents of the innovative drug companies expire. So that caused the patent dispute. So this new provision is about to solve this problem. But in this new law, it just gives an outline of this system. Basically, in this new law, it says a dispute can be resolved through two routes, judicial routes or administrative routes. And the drug market approval may be suspended within a specified time limit pending decision of the dispute. Here you can see there's a link between the market approval of the generic drugs and the patent of the innovative drug companies. The new law asks NMPA and the CNIPA to jointly formulate the measures of implementation. The last pillar of the amendments is about utilization of patents. Actually, one of the objects of this new law is to encourage the use of patents and the share of patents. In this new law, an open licensing mechanism is introduced. This is a direct response to the object. The whole idea is to use this open licensing mechanism to promote technology transfer and the utilization of patents. It works like this. First, a patentee can request from CNIPA for open license for patent, and the CNIPA announces the open license for the patent, along with the licensing fees for patent and the patent and the payment details of the licensing fee. And then a licensee to be can inform the patentee in written to practice the patent according to the licensing fee and the method of patent specified in the CNIPA's announcement. As an incentive, the annuities of the patent can be reduced during the open licensing period. This open license can only be a general license, not a sole license or exclusive license. And also, the patentee can revoke the open license for patent. So, as you can see, this mechanism basically is providing a system for facilitating the technology transfer and utilization of patents. And there are some other elements in the new patent law. First of all, apart from the patent term extension for pharmaceutical patents, there is a general patent term extension for invention patents. I think many of you know that in terms of patenting activities, China has topped the world over the years in terms of filing numbers, no matter for domestic filings or for PCT international filings. But the downside of the huge number of the patent application in China is there has been a huge backlog in the patent office for examining the patents. Although the patent office has established quite some patent examining centers, and they hired a lot of patent examiners. Still, there is a huge backlog in patent examination. So many patents, patent application actually cannot be timely examined and granted. That this provision is to address this problem. With this new provision, now it is possible to extend the patent term for invention patents due to unreasonable delay by the patent office. If a patent is granted more than 4 years from its filing date and 3 years from the requesting of the substantive examination. Please note that this provision is only applicable to invention patents because utility models and designs are not subject to substantive examination. In the new law, there are also changes regarding employee or service inventions. In a way, this provision is also related to promoting technology transfer and utilization of patents, because this provision is basically encourage the employer to share the patents with the employee inventor. And also the employer is encouraged to share financial gains from patents with employee inventors. For example, by stocks, by options, and dividends. This provision actually is also related to the provisions of remuneration and awards for the patents for the patents that is developed by the employees. So this is something probably we should note. In the end, there are some provisions regarding bad faith patenting activities and abuse of patent rights. As we just mentioned, over the years, we have seen a huge number of patent applications in China. And in fact, China has been criticized in that actually in this huge number of patent applications, there are a lot of patents which are low quality patents and even junk patents. I think to some extent this is true because many of us know that in China a situation is that actually many applicants file patent applications not for the patent itself. It's actually they file the patents for obtaining the government subsidies or some other kind of financial support. China actually has aware of this situation and is willing to change the situation. And China has already issued announcements to stop all the local subsidies by the end of this month for filing activities and prosecutions. I think by putting this provision in the new law and together with China's initiatives to crack down the bad faith patenting activities, I think we can expect less patent applications in the near future from the domestic applicants. I think this is important because it's probably, we hope it can it can reduce the burden of the overstretched patent office, so that they can put their resources, their energies on the real patent applications. And also from the perspective of the foreign companies, including the SMEs, I think this can mean in the future, when it comes to FTO search, you may say less roadblocks of the low quality patents. So it also can save a lot of time, cost, energy for the companies who need to do the FTO search. So all looks good in the law, but what about the implementation? Actually, the new law has come out. The draft implementing regulations of the patent law has not been finalized. But I think we should be able to expect the implementing regulations very soon. In addition to the implementing regulations, there have been a series amendments of patent examination guidelines since 2019. The coverage of the amendments was quite extensive to cover such as the examination standard for inventions from the area of computer science, some examination rules about pharmaceutical patent applications, and some general standard examination standard for assessing patent novelty and inventiveness. And also, very importantly, the judicial interpretation on trials of IP civil cases involving punitive damages has come into effect on the 3rd of March of this year. This judicial interpretations actually provided some guidelines about the application of punitive damages, such as the definition of willful infringement, the criteria to be used to calculate the multiple for the punitive damages. There are also, as we just mentioned, there are also some regulations, draft regulations that are in progress by the NMPA and the CNIPA and the Supreme People's Court regarding the patent linkage system. And we can expect more to come, more amendments of patent examination guidelines and the judicial interpretation, administration rules and the court guidelines in patent practice. So, lastly, there are some takeaway points. First of all, we can see that from the new patent law, we can see China is willing to improve the patent enforcement. And the China IP landscape is increasingly pro-patentee. We see the level of patent protection has been further increased. The patent term can be extended for general purpose or for specific situations such as pharmaceutical patents. We can also see the expansion of the patentable subject matter because we now have partial design protection, which can be used to better protect GUIs. Also, we can see the patent enforcement has been further strengthened in terms of damages, including statutory damages and punitive damages. We have seen the improved evidential rules in favor of plaintiff in litigation. Also, the administrative authorities have been given more power to deal with patent dispute. And lastly, from the new law, we can see there are some provisions that are designed to encourage the use of the patents and improving patent quality. Open licensing mechanism is one example. I think SMEs may consider this open licensing system as an option for monetization of their patents. Also, there are some provisions regarding tracking down the batches patenting and abuse of patent rights, which are all good in the long term from the perspective of patentee or right owners. So I think that wraps up my presentation. If you have some questions, we can try to answer them after the material.
Yes, actually, I have a question regarding how to judge the violation. For instance, it's based on the sales or based on the usage. If, like say, the pharmaceutical product, if anyone manufactures that but not sell that, they used for their own kind of surgery or operation, is that count as a violation?
Sorry, could you please introduce yourself?
Well, I'd rather not expose the company name because it's a little bit sensitive. So, yeah, my name is Raymond.
Thank you.
Raymond, sorry, can you repeat your question because I did not quite follow it.
Yeah, my question is how to judge the violation of the IP protection. For instance, it's based on the sales activity or usage activity. For instance, for the pharmaceutical or the solution, if they manufacture but not sell into the market, just used in their own kind of operation, is that also?
Yes, I think I understand what you mean. I think you asked a quite general question. You asked about actually the definition of infringement for IP violation, because IP has different forms, such as patents, copyrights, and trademarks. I think I can answer your question from the perspective of patents. In the patent law, the infringement of patents is defined as the use of patent, including the sale of the patented product, also for sale of patents, or the use of the patented products, and also imports the importing of the patented products. They can all be considered as infringement of the patents. But for other areas of IP law, there may be some differences in the definition of infringement. So to answer your question, I think if you are referring to a patented product, the use of the patented product or the sale of the patented product are all considered as infringement.
Okay.
Oh, thank you.
Thank you, Xiaofan, and thank you for your answering the question and the wonderful presentation. For time efficiency, I propose we will ask Mr. Matthias Zobimandi to continue his presentation in copyright law, and then we will save like 20 minutes for Q&A session. And during this time, anyone online or on site who has questions can ask the presenters, and you can also use the Zoom group chat and type in your questions in case you have any questions for the presenter. Okay, then let's welcome Matthias Zubimandi for his presentation. The stage is yours.
Thank you very much. I hope you can hear me well.
Yeah.
Yes. Well, myself, I'm going to talk about the vision of the copyright law. The patent law was not the only one that was modified last year and came into effect recently. We also have seen changes in the copyright law. I will first do an introduction about copyright in general. In each part, I will also include some general topics, some general explanation for those who are not familiar with copyright, so you have a better understanding of what I am talking about. First, to introduce copyright, we have to know and understand what is exactly what copyright protects. We have to distinguish ideas and with the expression of an idea. An idea, it's a thought that the person may have. It's just purely mental. That cannot be protected by copyright. It can be protected instead if that the expression of that idea. It's how that idea was taken into practice, how it was shown, and how it can be tangible, how can be appreciated by other people. That is what is being protected. Also, for high protection, the law requires one specific aspect. This idea has to be original. The concept of originality is not linked to the quality of the final work, but with the idea of the concept that it was made independently, that it was not copied, but it was an effort of the author. When we talk about copyright protection, we always talking about, or IP rights in general, we're talking about registration. In the case of copyright, it is also to protect it with the registration. However, since China is part of the Berne Convention, the registration, technically speaking, is not necessary. The copyrights of final works receive protection even if they are not registered, and they start receiving this protection when they are already completed. When the authors consider the final work is done, it already can be protected. Nevertheless, in practice, it is very difficult to prove that you are the author of your work if you don't have any registration. For that reason, for those companies that they rely heavily on art, or for those companies that are investing in, for example, software or databases, we strongly advise the registration with the Chinese Copyright Office. But let's jump directly on the amendments of the new copyright law. First, we have to distinguish that there is a problem, or there was a problem with the previous law, that it's been addressed by this new modification, which is the types of work. In the previous law, in the Article 3, there were listed some works that were protectable. This means that your type, those lists, that list included certain type of work, for example, literally, for example, paint. And if your work was not in that list, then it was not going to receive protection. This brought the problem with the new technologies, since there were new type of works that their definition did not match exactly what was content in the copyright law. They were not receiving protection. So this new law brought changes on that aspect to address this new type of work and include them or giving them this type of copyright protection. This change was made first modifying how works are defined. Now, all original intellectual creations in the literary, artistic, or scientific domain are capable of being reproduced in tangible form will be protected. This means that any work that is original, intellectual, that can be reproduced and can be taken into a tangible form will receive protection. Before, there was also an addition that said that for receiving protection, the work should be recognized as protectable by the law or by the administration. Now, this requirement was deleted. This means that if any work that fits these 4 requirements that I mentioned before, in that case, it will be possible to receive protection regardless if there is no mention in any other legislation in China, making this new open definition in which allows to new technologies, to new type of works to come and still be protected. But we also have to mention certain special cases that deserve some minutes of attention. First one is inclusion of audiovisual works. Before, the concept of audiovisual was not mentioned. It was mostly kept for cinematography, but now this broader concept showed up, making the protection allowed to not only cinema and movies, but also including short videos, video games, and even interactive audiovisual works. But also there is another case that is very interesting, is that the previous law used to deny protection to news on current affairs. This was modified to actual news. This means that news that merely describe facts, they will not receive protection. But those news, those articles that do have originality, in which the author did include new visions, opinions, point of view, etc., then they will receive protection from copyright. So for those companies that dedicate themselves to inform, this copyright law is going to be, this new amendment is going to be very, very important. We also have modifications in the new uses of work. There are new rights under the copyright law. The previous law had a certain amount of rights that were described. There were 4 personal rights and 12 property rights. When we talk about copyright, we have to understand that at the end of the day, what we have is a monopoly over a final work. This means that the owner of the copyright can do or perform certain acts like reproduce, show, translate, modify, etc., publish, for example, and that person is the only one capable of doing those acts or authorize a third party to do them. This new law modifies those traditional uses and brings new ones. For example, digital reproduction. Now, according to the new law, digital reproduction, this means the duplication or reproduction digital, is going to be one of those new uses. So now it's very clear that when we're talking about a computer, when we're talking about internet, when we're talking about this digital world, then reproduction, duplication should be authorized by the copyright owner. The lease. Now, the work owners of audiovisual works and computer software will be capable of leasing the original version or the copies of it. Also, in the case of broadcasting, there is a new modification that allows those who want to authorize the broadcast of a work and making it even more clear. The previous law was mentioning that this broadcast should be authorized when it's wireless. This means when there is no wire involved. Now this expression was eliminated, so it's very clear that copyright owners can authorize the broadcast via internet. This seems quite obvious, but due to how the previous law was written, brought actually many discussion about if the broadcast online was or was not possible to receive copyright protection. So if there was someone broadcasting a work without the authorization of the copyright owner, there was a discussion about if there was a copyright infringement or not. Now it is very clear that in this scenario there would be an infringement and that person would need the authorization of the copyright owner. Finally, the network dissemination is also included as one of these new uses. Before, dissemination was included as dissemination of the work. This means that you were making a copyright infringement if you were disseminating the work itself. Now the law talks about network dissemination, including, for example, the links to the work. You may be disseminating not the work, the final work, not for example, the video, the book, the movie. But if you are disseminating the links to have access to a work, then you're also committing a copyright infringement. This modification seems simple, but actually have many consequences in practice. Yeah, next slide. There are also modifications regarding the ownership of copyrights. When we talk about authorship and ownership, we have to make a distinction. Authorship is, when we talk about authorship, we're talking about the person who made it, who actually did the effort to get the final work done. Normally, the author is also the owner, the one that will receive the copyrights. However, when we talk about ownership, it could be that the real owner is not the author, that the ownership over the work was given, maybe by a license, maybe by a contract. So we have to distinguish and we have to be careful that when we talk about authorship and when we talk about ownership, they may not be the same person. We have to add another distinction or any other aspect to that distinction, because the author should always be recognized as the author, regardless if he gave or not the ownership of the copyright. This means that the authors, they will still keep one of or some of the copyrights that are personal but not property rights, and the ownership will be only receiving the property rights of the copyright. But the law brought some modifications regarding ownership. The most relevant one is the presumption of the ownership. The new law says that the person who is mentioned in connection with the work will be presumed as the author. This means that as long as a person is connected with the work, for example, it could be done in the communication, then it will be immediately presumed that that person is the author. Of course, the law also says that it is possible to present contrary evidence and have a discussion about the real authorship of the work. And also we have to understand that there's another way of presuming the authorship that is was already contained in the previous law and it's also mentioned here in this one, that is the registration. When you register a work under your name, presumably you are also the author, except if you, of course, if you mention the contract. But there are also some rules regarding how to, in the case of a joint authorship, in the case that there are several authors involved, how to deal with exploitation when those authors do not agree on the way. The law says that when there is a disagreement, each author will have the capacity of exploiting, keep exploiting the final work, but some of the ways that this final work can be exploited will not be available. This means that in the case of giving any assignment or for providing exclusive licensing or for pledge, then we will need the authorization of all the authors. If we don't have unanimous decisions on this, then these types of exploitations will not be available. Also, the law brings modifications in derivative works and compiled works. These the rules about how to exploit this type of works are modified. Before they used to have their own articles. Now they are all included in one article, the Article 16, which basically says that in order to create any type of these works, you will need the express authorization of the original author. This means of the author of the original work that you will base for creating your derivative or your compiled work. There are also, regarding ownership, there are modifications about how audiovisual works are created or how the ownership is assigned. There is the basic rule that separates cinematographic audiovisual works that the ones that are not cinematographic. In the case of cinema, the law is very clear. They said that the producer of the audiovisual work will be considered as the owner, except any packing contract. In the case of audiovisual works that are non-cinematographic, then we have different rules. The first one is we have to check the agreement between the parties to see how to give the ownership. If there is no agreement, then we will fall under the regular rules of co-authorship and go to the main and whole structure that used to really be present in the law. But also there is the case in which we have an audiovisual work that can be splitted and separated in different type of works. For example, we have a movie, but the movie can be cut in short videos, and for example, there is music that can be exploited separately, and the law specifically says that the authors of each part, this means, for example, the author of the song that is present in the movie, will keep the right to keep exploiting them separately, of course, except if there is any act in. Finally, there's, as I mentioned before, there are modifications regarding the news that are not purely facts, but now these are a new type of work. And of course, there are rules regarding how to exploit them, how to design the ownership, the journalist, the person who is giving his opinion or her opinion about facts, giving their point of view, adding original information to pure facts, then that person will be considered the author and will be considered the author. We go also to the modifications on limitations over the copyright. When we talk about limitations on copyright, we're talking about circumstances in which a person can use a copyright, can use the work protected by copyright even without the authorization of the owner, and still not being made an infringement. Normally, this is associated with the concept of fair use. Fair use is coming from the American common law that says that under certain conditions, people can freely use a work. Generally speaking, they set some rules which are also replicated in the new amendments of the copyright law. The law basically have a list of 15 different circumstances which will be considered as fair use. For example, person can use a protected work for study, can make copies for research without infringing or committing any infringement. However, there are certain rules that they have to follow in which they do so. First, the name of the author and the name of the work should be always present, so we can recognize who is actually the person who made it. This use or these circumstances should never go against the interests of the real owner of the work, shouldn't never damage the rights, and it should not alter or prejudice the use of the work. If a situation is under one of those circumstances listed in the law and complies with these requirements, then we are in the case of fair use in China. Also, the law brings or close this article with an expression that believes that the cases of fair use can be determined by law or administrative regulation. This means that in the future, without modifying the copyright law, we may see new scenarios of fair use in which people will be capable of using taking advantage of protected work in this way. Here we're always talking about purposes that should not follow profit. For example, people can do free performance in the street about the protected work, protected dance, for example, but they should never be remunerated. They should never collect fees. There shouldn't be any aim of profit. This is the key aspect of the limitations, that it should never follow for profits. Otherwise, they would be affecting the normal exploitation of and of course, also, the law brings exceptions for example, to copy or to reproduce, to translate protected works in order to make them accessible to people with disabilities. Finally, I will briefly talk about some other changes that I consider that very relevant. First, we have to talk about neighboring rights. Neighboring rights are those rights that are close to copyrights, that they are not, they don't show up or they don't appear because of a person doing the effort or creating the work, but most of the time because it for those who are taking care of the dissemination or to make available the work. When we talk about neighboring rights, we're talking about the publisher, the performer, the producer, right? Yeah, and the people who didn't make the work, but they are in charge of exploiting them to make it available to disseminate. There are two new neighboring rights that were included in this law. The first one is the right to lease in the case of performers, and the right of broadcasting, as I mentioned before, in the case of producers. Finally, I have to talk about changes on liabilities in case of an infringement. These changes are also connected with the ones that my colleague mentioned for patent law, because they are in the same line of increasing the protection that intellectual property rights have in China, generally speaking, because also these changes we saw them when the trademark law was modified. basically, there is a change on how we calculate the damages. There is a first rule that have to analyze, or judges have to analyze when deciding how to calculate the damages. First is checking the actual loss of the author, of the owner of the copyright in case of the infringement, but also check the illegal gains that the infringer obtained for doing such infringement. If it's not possible to analyze this information, then there is a second rule included that the judge should estimate what the license would have been if the infringer would have asked or requested for a valid license, how that person should have paid for, for obtaining the license. That is a way of calculating damages. But again, we also have punitive damages and statutory damages included and added in this new law. In the case of punitive damages, we are talking about damages that were serious, that really damage the exploitation of the work. These are an increase of 1 up to 5 times the original damages or the actual damages calculated. And in the case of statutory damages, here we're talking about damages that when it's very difficult to calculate the damages, there is a fixed way of establishing an amount of damage, and it would be from 500 up to 5 million renminbi. Finally, the law gives more power to courts. For example, they can request the infringer to have access to their books, to their account material, in order to check how much profit they obtain for the exploitation. This, in some way, is also a change in the burden of the proof, because if the infringer rejects to provide this type of information, then it could be, or the damages could be calculated according to the estimation done by the copyright owner, which of course will always be more of what the infringer will claim. But also courts will have a new power, that is that they will be able to order the destruction of infringing copies. The next slide. This is the end of the presentation. For here, the ones that are present, you may find an evaluation note, so you can evaluate the presentation. And for those who are online, please scan the QR code and leave us your opinion about the presentation. We can proceed with the Q&A.
Songxi, you're on.
Yeah. Okay. Thank you, Matthias, for the presentation on the newly amended copyright law. So anyone who has questions, feel free to type in the group chat room or ask the questions directly.
Okay, I have actually a question here for today, and that would be on the patent law, because you mentioned that there would be a phasing out of subsidies for patents, and that would potentially help with the abuse of filing patents, right? But I was wondering if you could see any potentially negative impact in terms of incentivizing smaller companies to file patents, and what kind of impact would that have?
You mean the phasing out of the subsidies, the local subsidies? I think that's announcement. Basically, we have a great impact on domestic applicants, because it has been the domestic applicants who can claim the subsidies from the local government. But because of many patent applications actually filed voting for the sake of the obtaining subsidies. That is the reason why China wants to stop this and then stop all the local subsidies by the end of this month. So generally speaking, it will have great impact on the domestic applicants, and it will affect some patent agencies who have been helping this kind of plans. From the perspective of the foreign company, I think that it's generally a good thing, because when you try to come into the markets, you will face a less roadblock of this kind of patents, because if there are a lot of patents out there, you need to perform a lot of FTO searches to make sure you can safely enter the market. So I think, generally speaking, it is a good thing from the perspective of foreign companies, including SMEs, and also because the number of the patent filings for this kind of application will drop, and the burden of the patent office will be reduced to some extent. So I think it generally is a good thing.
Thank you. If nobody else has, yes?
Okay. Hi, Xiaofan. I also have a question with regard to the newly amended patent law. Is that I think you mentioned the new law forbids abuse of patent rights for excluding competition. I'm just wondering, so because SMEs or innovative companies, innovative foreign companies, they want to enforce, they want to protect their innovation by like filing patent and then enforce their patents. And now we face the term like abuse of patent for excluding competition. I'm just wondering, how do we have to balance between these two sides, and if there is any case in practice that have been like recognized as this kind of abuse of patent rights, so we can avoid that.
Yeah. I think the reason behind this provision about the good faith patenting activities and the abuse of patent rights is basically China's response of the development of patent practice from quantity, from a practice focused on quantity to a practice focused on quality. When it comes to abuse of patent rights, because this is just a general rule in the patent law, we haven't seen the clear definition about the abuse of patent rights. But in this provision, the abuse of patent rights is related to competition, which means that this provision may be interpreted in combination with anti-competition law of China. So if an abuse of rights relating to excluding competition or limiting competition is found by the court, then I think then the party probably will be punished by using the two laws. There are quite some clear provisions about the punishment of the anti-competition activities in the anti-competition law. I think that's something we need to know. From the perspective of SMEs, I think if when they try to enforce their patent rights, if they have done the proper due diligence, they should not be worried much about this provision. This provision is just for the activity of abuse of patent rights relating to competition.
Okay, thank you for your explanation here. Actually, I have another question with regard to the administrative authorities who will be given more responsibility to solve patent infringement dispute. But as we know, sometimes patent is not only a legal matter, but is also but maybe a very complex technical issue. So I'm just wondering for local IP offices if they have the capacity to solve very difficult technical problems when deciding whether this is a patent infringement or not, and if there will be some local protection to the local companies when they do enforcement at the IP office.
Yeah, this is a very good question. Yes, it is true. There are always technical aspects involved in patent infringement issues and patent disputes. I think you have known that in the specialized IP court, when the judge decide cases, now they can seek help from some technical investigation officers in the IP court. This is something quite special that has been introduced in the patent court system in recent years. I read somewhere that actually in some local offices of CNIPA, they are also considering to introduce the technical investigation officers to help them to deal with patent disputes when they have some technical problems. So I think this is a good sign that I hope we can see more and more local IP offices having this kind of technical investigation officers.
Okay, thank you.
We have one last question from Shanghai, and I think that looking at the time, we might have to make it the last one. So I don't know if you can see it.
Yes. In the past few years, the function, value, and the impact of the patent system are in the process of adjustment and implementation so as to balance existing right holders and new entrants to the market. Is this still the case after the updates to the patent law? Have the updated patent law affected the technology innovation environment in China? Yeah.
Well, I think this is Yeah, this is a very big question. There's, I think one of the objects of patent law is always to strike balance between the parties, the right owners, the party who needs the access to the patents, and also the public. This is a very big question. China has, I think, if we look back at the first 3 amendments of the patent law, for each time the amendments were made in response to the then situation, socially or technology wise. They always try to make the balance to meet the needs of different parties at that time. And for when we talk about the most recent amendment to patent law, as I mentioned in my presentation, I think it is generally believed that this amendment of patent law is very pro patentee. It's very pro patent owners. I think this actually matches the current situation of China, because China is from the very top. China is trying to encourage innovations from different kinds of industries. That's why we can see so many amendments in the new patent law that are in favor of patent owners, in favor of plaintiffs when it comes to litigation, and in favor of the parties, in favor of the parties who need to use the patent by the fair sharing scheme. So I think, I don't know if I have answered your question, because this is a very big and general question, but in general, we consider this new patent law will encourage the innovation further in China.
It seems that Shanghai said that it makes sense.
Yeah, thank you.
So I think that looking at the time, perhaps we can wrap up the meeting. Would you like to say some closing remarks?
Okay, so I just want to say that I want to thank everyone who is joining online and at office to the webinar today, and also I would like to appreciate a lot for my to the speakers, Xiaofan and Matthias, for their excellent presentation on the newly amended patent law and copyright law. So we will continue to have this webinars held by the chamber and held by the chamber. So stay tuned and stay focused. Okay, so have a nice weekend to everyone.
Thank you. Bye.
Thank you very much. Bye.